Download this code from codegive.com, link in the description below. Tutorial, Understanding and Navigating Rule 1.7, A. Conflicts of Interest, Directly Adverse Clients. Rule 1.7 of the ABA Model Rules of Professional Conduct, and its corresponding rules adopted by individual states, addresses conflicts of interest that can arise when a lawyer's representation of one client is compromised by their responsibilities to another client. Specifically, Rule 1.7, A, deals with the directly adverse conflict situation, which is a critical and commonly encountered type of conflict for lawyers to understand. This tutorial will provide a detailed and informative exploration of Rule 1.7, A, focusing on what constitutes a directly adverse conflict, the rationale behind the rule, how to identify and resolve such conflicts, and best practices for managing your practice to minimize these situations. We'll include code examples, in Python, to illustrate how to model potential conflicts and implement conflict checking logic. The core of Rule 1.7, A, representing directly adverse clients. Rule 1.7, A, states, in simplified terms, except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if 1. The representation of one client will be directly adverse to another client, or 2. There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client or a third person, or by a personal interest of the lawyer. This tutorial focuses on Rule 1.7, A. 1. Directly adverse clients. Key components of directly adverse conflicts ****. Concurrent representation ***. The conflict arises when you are simultaneously representing two clients. This means the lawyer-client relationship with both clients exists at the same time, even if the work being done for one client is minimal. Representation of a former client is handled under Rule 1.9. Direct adversity ***. This is the core concept. The representation of one client must be directly adverse to the interests of another current client. This usually means the clients are literally on opposite sides of the same matter, such as in a lawsuit or a negotiation. Matter ***. The matter refers to a specific legal issue or transaction. The conflict must arise within the same or substantially related matter to typically trigger a direct adversity issue. Representing two clients in completely unrelated matters usually doesn't create a direct adversity conflict unless there's another element at play, like confidential information or a potential for one client to undermine the other's interests. 2. What constitutes directly adverse? Examples. Here are some common scenarios where a direct adversity conflict arises. 1. Litigation ** representing plaintiff A in a lawsuit against defendant B, while simultaneously representing defendant B in an unrelated matter. This is the classic example. Even if the unrelated matter is completely different, example B's estate planning, the direct adversity in the litigation is a conflict. 2. Transactions * representing both the buyer and the seller in a real estate transaction, without informed consent and a conflict waiver. The buyer wants the lowest possible price, while the seller wants the highest possible price. Their interests are directly opposed. Limited exceptions can exist with very sophisticated waivers and informed consent, but it is highly disfavored. 3. Negotiations * representing two competing businesses that are negotiating a joint venture agreement where their interests are fundamentally in opposition regarding the terms of the agreement. 4. Settlement negotiations * representing multiple plaintiffs in a lawsuit where the total settlement offer is insufficient to fully compensate all plaintiffs, and the lawyer must allocate the settlement among them. This creates direct adversity because each plaintiff's desire for a larger share directly diminishes the share available for other plaintiffs. This often requires informed consent and a well-documented allocation plan. 5. Cross-examination *. A lawyer should not cross-examine a current client in a matter where the client is adverse to another client of the lawyer. This would require the lawyer to attack the credibility of a client, which is a direct breach of the duty of loyalty. 6. Policy positions *. While more complex, sometimes directly adverse conflicts can arise from taking policy positions on behalf of one client that directly contradict or undermine the legal interests of another client. This is particularly relevant for lawyers engaged in lobbying or representing organizations with public policy agendas. This is harder to identify but can cause problems. Important considerations *. Appearance of impropriety *. Even if the actual harm to a client's interests is minimal, the appearance of impropriety can be damaging to the lawyer's reputation and the integrity of the legal profession. Duty of loyalty *. The rule against direct adversity is rooted in the fundamental duty of loyalty that a lawyer owes to each client. Loyalty requires a lawyer to act in the client's best interest, which is impossible when the lawyer is simultaneously acting against that client's interests. Confidentiality *. While separate from the direct adversity issue, the duty of confidentiality is closely related. Even if a lawyer can theoretically avoid harming one client's interests in the direct representation of another, the risk that confidential information from one client might be used to the detriment of the other is a serious concern. 3. The rationale behind Rule 1.7a. The prohibition against representing directly adverse clients serves several important purposes. Protecting client confidentiality *. Representing adverse parties creates a risk that confidential information learned from one client might be used against that client in the representation of the other. This violates the lawyer's duty of confidentiality. Preserving client loyalty *. A lawyer's loyalty to a client is compromised when the lawyer is simultaneously representing the client's adversary. The client may reasonably feel betrayed or that the lawyer is not fully committed to their cause. Maintaining public confidence in the legal system *. The appearance of a lawyer working against the interests of one client while simultaneously representing that client undermines public trust in the legal system and the integrity of the legal profession. Preventing conflicts of interest from undermining the quality of representation *. A conflicted lawyer may be unable to provide zealous representation to both clients because of the inherent tension between their competing interests. The lawyer may pull punches or avoid certain strategies to avoid harming the other client. 4. Identifying directly adverse conflicts, a systematic approach. Identifying direct adversity conflicts requires a systematic approach. 1. Client intake *. Implement a robust client intake process that gathers detailed information about the prospective client, the nature of the legal matter, and the identity of all adverse parties. This is the most critical step. 2. Conflict check system *. Maintain a comprehensive conflict check system, manual or automated, that allows you to cross-reference the names of all clients, adverse parties, witnesses, and other relevant individuals or entities in your database. 3. Matter scope analysis *. Carefully define the scope of the proposed representation. What specific legal issues will you be handling for the client? Who are the potential adverse parties? Understanding the scope is essential for determining whether the representation will be directly adverse to another client. 4. Ongoing monitoring *. Conflicts can arise even after representation has begun. Continually monitor your client roster and new engagements to identify any potential conflicts that may develop. 5. Professional judgment *. Ultimately, the determination of whether a conflict exists requires the exercise of sound professional judgment. Consider all relevant facts and circumstances, including the nature of the relationship with each client, the scope of the representation, and the potential for harm to either client's interests. V. Resolving directly adverse conflicts, consent and waiver, Rule 1.7, b. While Rule 1.7, a, generally prohibits representing directly adverse clients, Rule 1.7, b, provides a limited exception. b. Notwithstanding the existence of a concurrent conflict of interest under paragraph a lawyer may represent a client if 1. The lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. 2. The representation is not prohibited by law. 3. The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal, and 4. Each affected client gives informed consent, confirmed in writing. Explanation of the conditions for waiver ****. Reasonable belief in competent representation ***. The lawyer must reasonably believe that they can provide competent and diligent representation to both clients, despite the conflict. This is a high bar and requires careful self-assessment. If the conflict is so severe that competent representation is impossible, consent is not permissible. Not prohibited by law. Some conflicts are so egregious that they cannot be waived, even with client consent. For example, in some jurisdictions, it is never permissible to represent both parties in a divorce proceeding. No client versus client claims in the same tribunal. This is the crucial limitation. You cannot obtain consent to represent client A against client B in the same litigation or proceeding. This rule is absolute. The adverse parties in the same litigation will always be on the opposite side of the table. Informed consent, confirmed in writing. The clients must provide informed consent, meaning they must fully understand the nature of the conflict, the potential risks and benefits of waiving the conflict, and the alternatives to waiving the conflict, such as retaining separate counsel. This consent must be confirmed in writing, typically in the form of a conflict waiver letter. Elements of a valid conflict waiver ***. A valid conflict waiver should include the following. Clear identification of the clients. Specify the names and identities of all clients involved. Description of the conflict. Explain the nature of the conflict in plain language, including why the representations are directly adverse. Potential risks and benefits. Discuss the potential risks and benefits to each client of waiving the conflict. This includes the possibility that confidential information might be used, even inadvertently, against them, the potential for divided loyalties, and the potential for less zealous representation. Also, discuss any benefits, such as cost savings or the lawyer's expertise in a particular area of law. Alternatives to waiver. Explain that the clients have the right to seek independent counsel and that they can refuse to waive the conflict. Right to revoke consent. Inform the clients that they have the right to revoke their consent at any time, although revocation may not be possible in some circumstances, example if the lawyer has already invested significant time and resources in the representation. Acknowledgement of understanding. Include a statement that the clients have read the waiver, understand its terms, and voluntarily consent to the representation. Signature lines. Provide signature lines for each client. When waiver is not possible. It is crucial to remember that not all conflicts can be waived. The lawyer must make a reasonable judgment that the representation can be competent and diligent, and the representation must not involve client versus client claims in the same tribunal. 6. Code example, modeling conflicts and implementing conflict checking logic, Python. Here's a Python example to illustrate how to model potential conflicts of interest and implement basic conflict checking logic. Explanation of the code asterisk. One client class asterisk represents a client with a name and a set of interests. The interests field is intended to capture areas of business, legal issues, or other relevant concerns that might trigger conflicts even in seemingly unrelated matters. Using a set allows for efficient checking of overlapping interests. ToMatter class asterisk represents a legal matter with a name, a set of involved parties, and a subject underscore matter. 3 Conflict checker class asterisk. This is the core of the conflict checking logic. Asterisk clients, a dictionary to store all clients, keyed by client name. Asterisk matters, a list to store all matters. Asterisk add underscore client, adds a client to the client's dictionary. Asterisk add underscore matter, adds a matter to the matters list. Asterisk check underscore direct underscore adversity, this is the key function. It checks for direct adversity conflicts by iterating through the existing matters and clients. It checks if the new client is on the opposite side of the other client. Asterisk check underscore related underscore interests, checks whether the new client's interests overlap with those of existing clients. This can indicate a potential conflict even if there's no direct adversity, especially if the new matter could negatively impact the other client's interests. How to use the code asterisk. 1. Customize asterisk. Adapt the client and matter classes to include more relevant information for your practice, such as the type of client, individual, corporation, etc., the specific area of law involved, and any other relevant details. 2. Populate asterisk. Populate the conflict checker with your existing clients and matters. This data should be stored in a persistent database, example SQLite, PostgreSQL, MySQL, for a real-world application. 3. Integrate asterisk. Integrate the conflict checker into your client intake process. Before accepting a new client or matter, run the check underscore direct underscore adversity, and check underscore related underscore interests functions to identify any potential conflicts. 4. Database integration asterisk. For a real application, replace the in-memory dictionaries and lists with database queries to efficiently retrieve and store client and matter data. Important considerations for the code example asterisk. Asterisk simplicity asterisk. This is a simplified example. A real-world conflict checking system would be far more complex, taking into account related parties, business affiliations, parent companies, subsidiaries, and other relevant factors. Asterisk subjectivity asterisk. The determination of whether a conflict exists often involves subjective judgment. The code can identify potential conflicts, but it cannot make the ultimate decision. Asterisk maintenance asterisk. Conflict checking systems must be regularly updated to reflect changes in the law, new court decisions, and evolving ethical standards. Asterisk error handling asterisk. Include robust error handling and logging to ensure the system operates reliably and to facilitate troubleshooting. 7. Best practices for managing conflicts of interest. 1. Implement a comprehensive conflict check system asterisk. As discussed above, this is essential. 2. Train your staff asterisk. Ensure that all lawyers and staff members are trained on the firm's conflict of interest policies and procedures. 3. Document everything asterisk. Maintain detailed records of all conflict checks, consent waivers, and communications with clients regarding conflicts. 4. Err on the side of caution asterisk. If you are unsure whether a conflict exists, it is always best to err on the side of caution and consult with an ethics expert. 5. Seek guidance from Ethics Counsel asterisk. Consult with Ethics Counsel or your state bar's ethics hotline when faced with complex or unusual conflict situations. 6. Regularly review and update your system asterisk. Conflict of interest rules and case law are constantly evolving. Regularly review and update your conflict check system and policies to ensure that they remain compliant with the latest ethical standards. 7. Maintain client confidentiality rigorously. Strong data security and access control policies are vital to prevent inadvertent disclosure of confidential client information. 8. Be especially diligent when accepting new clients who were previously represented by another firm. In these situations, it's important to understand if the previous attorney-client relationship has been properly terminated, as a continuing conflict can result. 8. Consequences of violating Rule 1.7a. Violating Rule 1.7a can have serious consequences for the lawyer and the firm, including disciplinary action. The lawyer may be subject to disciplinary action by the state bar, including suspension or disbarment. Disqualification. The lawyer may be disqualified from representing a client in a particular matter. Malpractice claims. The lawyer may be sued for legal malpractice by a client who has been harmed by the conflict of interest. Loss of fees. The lawyer may be required to forfeit any fees earned in the representation of a conflicted client. Damage to reputation. A conflict of interest violation can severely damage the lawyer's reputation and the reputation of the firm. 9. Conclusion. Understanding and complying with Rule 1.7a is crucial for all lawyers. By implementing a robust conflict checking system, providing thorough training to staff, documenting all conflict-related matters, and seeking guidance from ethics counsel when needed, lawyers can minimize the risk of violating this critical ethical rule and protect their clients, their practices, and the integrity of the legal profession. The Python code example, while simplified, provides a starting point for developing a more comprehensive and automated conflict checking system tailored to the specific needs of your practice. Remember that seeking informed consent is often possible, but it requires careful analysis and transparent communication with your clients. When in doubt, err on the side of caution and seek expert advice.